The pendulum of public opinion about Crystal Mangum swings positively when the truths of her case are known. Many people have developed feelings of ill will against Miss Mangum based solely upon what they have heard about her from the mainstream media since the 2006 Duke Lacrosse case. As a rule, the news coverage of Crystal Mangum has been suppressive, selective, and slanted. Of the limited media types following the Mangum case, the Herald-Sun's Durham daily newspaper has what is likely the most objective and accurate coverage about her. Its coverage of the August 15th motions hearing in the Mangum malicious prosecution complaint being excellent. Only the headline is objectionable because it focuses on relief sought rather than the crux of the complaint, which was Mangum's assertion that the defendants maliciously prosecuted her with the larceny of chosen action charge during her 2013 murder trial. A more acceptable headline would have read, quote, "Judge denies Duke Lacrosse accusers malicious prosecution complaint on the larceny charge," unquote. The well-written article, "Judge denies Duke Lacrosse accuser's request for new trial release from jail," by veteran reporter Virginia Bridges, published online on August 15th, focused on the hearing with impartiality and correctness. It most certainly did not dwell on the 2006 Duke Lacrosse case, as most media outlets are accustomed to devoting an inordinate amount of time to that mythic event when publishing any story even cursorily related to Crystal Mangum. An example of a malleable media misleading its audience by bending the truth and with misleading statements is represented by CBS 17 News' coverage of the hearing. Instead of being informative, as is the Herald-Sun article, the CBS 17 News is misleading based on suppositions instead of facts, generated to mold opinion rather than plant seeds of truth to enable a person to reach a sound conclusion on one's own. The critical dissection of the CBS 17 online article begins with its headline, which falsely describes Mangum as the, quote, "Duke Lacrosse accuser who killed her boyfriend," unquote. There has never been shown to be a nexus between the non-fatal stab wound Reginald Daye received from Mangum and his brain death or actual death. Records from prosecution discovery clearly demonstrate that Daye died after being electively removed from life support. Daye's placement on life support due to his comatose brain death. His brain death due to his errant esophageal intubation in treatment of his delirium tremens, and his delirium tremens brought about by Duke University Hospital's inability to bring his alcoholic withdrawal under control. Then the article claims that Mangum sued the Durham Police Department. Again, absolutely false. It is clear from all legal briefs that Mangum is suing a Durham police officer, Marianne Bond. This intentional falsehood conceals the identity of the defendant Mangum accused of wrongdoing. Shielding the identity of the wrongdoer from the public is the primary objective of this deceit. By writing, quote, "Mangum is no stranger to the courtroom," unquote, CBS 17 implies that Mangum is constantly in trouble with the law. For an example, it refers to the Duke Lacrosse case, which never went to trial and therefore provides no support for the claim. The second example given per the audio of its televised news report is referenced as the larceny charge in the 2011 case, which was in fact an accompanying charge in the murder trial held in 2013. And it is this charge of which the malicious prosecution complaint by Mangum is based, so naturally she would be in court for it. But to state that she is no stranger to the courtroom is not only misleading, but disingenuous at best.
update. In the Crystal Mangum case, you'll remember she's the woman who falsely accused Duke Lacrosse players of rape back in 2006.
Well, Marius, Mangum represented herself in court today during this lawsuit against the Durham Police Department as well as the Durham County District Attorney's Office.
False. The Mangum's lawsuit was against Durham Police Officer Marianne Bond. Never has the Durham Police Department been named as a defendant. The purpose for using it instead of the officer's name was to shield her identity in a case of wrongdoing.
Crystal Mangum is no stranger to the court system. She accused Duke Lacrosse players of raping her in 2006. Those charges were later dropped. Then, in 2011, Mangum was charged with stealing.
I was found not guilty of the charge.
The 2006 Duke Lacrosse case never went to court. Consequently, Mangum was not in court in this example used by CBS 17 News. The 2011 example given refers to the lawsuit at hand, the malicious prosecution lawsuit for charging her with larceny of chosen action. In other words, for stealing 2 cashier's checks, but the report doesn't mention that, because such a charge is ludicrous on its face.
Currently, Mangum is behind bars on a second-degree murder conviction after her boyfriend died from a stabbing.
Again, Mangum's boyfriend did not die from a stabbing. He died from medical malpractice at Duke University Hospital while being treated for his delirium tremens.
She believes the police department and district attorney's office acted maliciously in their prosecution.
Specifically, Mangum's complaint of malicious prosecution is solely restricted to the larceny charge and not to the overall prosecution, a point which the mainstream media has persistently muddled.
The judge did not agree, dismissing her case.
The court respectfully grants the motions, Ms. Mangum, to dismiss your complaint herein for untimely filing.
Wrong again. The judge never said she disagreed with Mangum's malicious prosecution lawsuit or its merits. She dismissed Mangum's lawsuit based on its untimely filing and improper service. No one has ever challenged the merits of Mangum's malicious prosecution lawsuit, but no one would ever know that from the biased media coverage. The article then goes on to falsely state as fact that Mangum, quote, falsely accused Duke Lacrosse players of rape, unquote. The next paragraph is totally confusing, as it stated, quote, in an unrelated case, unquote. Unrelated to what? Possibly unrelated to the Duke Lacrosse case, but the focus of this article had to do with larceny charges, claims by prosecutors that Mangum stole 2 cashier's checks from her boyfriend, whose name, by the way, is not mentioned in the article. What is more perplexing is that there is no mention of what was stolen. The logical reason for not explaining that 2 cashier's checks were stolen has to do with the absurdity of the charge, as cashier's checks of the remitter Daye are reissuable in the event of loss or theft. Prosecution of the larceny of chosen action charge is arguably the most unique in jurisprudence annals, especially in light of the fact that Mangum, being neither the remitter nor payee, had no way to convert the financial instruments to her benefit and made no effort to do so. The parade of media lies continues with the phrase, quote, after her boyfriend died from a stabbing, unquote. Again, the stab wound wasn't life-threatening, was successfully treated with surgery hours later, had a post-operative prognosis for a complete recovery, and had no record of any associated medical complications. Mr. Daye did not die from a stabbing, but secondary to malpractice by hospital staff. The instrument of Daye's death was not a steak knife, Rather, it was an endotracheal tube. It is important to keep in mind that on admission to Duke University Hospital, Daye had two medical conditions. First, the acute stab wound to his torso, and second, chronic alcoholism with acute ethanol intoxication. Though the article notes that Mangum believed that the Durham Police Department and the Durham District Attorney's Office acted with malice in its prosecution, there is no explanation that she linked the prosecution's malice to the pursuit of the larceny of chosen action charge. As explained by Ms. Mangum, the malice was due not only to the fact that the larceny of chosen action charge, a Class H felony, was used for the collateral purpose of elevating the murder charge to first degree via the felony murder rule, but the fact that the larceny charge was made with want of probable cause. This in spite of the fact that the defendants knew of Mangum's innocence of this charge. Readers of this CBS 17 article have no way of comprehending what the legal case brought by Ms. Mangum against the defendants is really about. Though the judge granted the defendant's motion to dismiss Mangum's malicious prosecution lawsuit based on its untimely filing in missing a 3-year statute of limitation, the media types failed to give Mangum's argument that during that period of time she was being represented by attorneys, and that she relied upon them to act in her best interest. Clearly they did not, for if they had, the filing of the malicious prosecution complaint would have been timely.
Article 5, 152-9 says that an exception can be given where there is a case of fraud or mistake for the statute of limitation. I was under legal counsel for the 3 years. The 3-year time frame that they're referring to. I depended on my attorneys to represent me. At that time, they were not acting in my best interest.
The article could have mentioned that Mangum's attempt to bring her friend Har to the stand as a witness was shot down by the judge due to objections by both defense attorneys, clearly not acting as ministers of justice seeking the truth, but instead as litigators seeking a favorable outcome for their clients. Finally, the article's photograph depicting Crystal Mangum in an orange jumpsuit was not from the hearing, as Mangum was attired in a black sweater and skirt with olive green undershirt. CBS 17 News had photographic footage of Mangum at the hearing wearing the nice aforementioned civilian outfit, but it elected to utilize one in which she was attired in prison garb, surrounded by sheriff's officers. Spectrum News coverage, though short and technically accurate in most of its statements, was critically flawed in its presentation. As in all coverage, except the Herald-Sun, Spectrum News shields the identity of the Durham police officer Marianne Bond by referring to the complaint as being against the Durham police. What is most egregious is its misrepresentation by stating that Mangum's lawsuit made accusations of, quote, malicious prosecution in her 2013 murder conviction, unquote. Technically true, but misleading in the sense that her accusations were restricted to the 2-count larceny of chosen action charge. That charge, which is the sole basis of her complaint, is never even mentioned in the article. This misleading statement is reiterated by stating, quote, Mangum claimed the departments acted maliciously during the 2013 case when she was found guilty of second-degree murder of her then-boyfriend Reginald Daye, unquote. Again, no mention of the larceny of chosen action charge. A reasonable person would surmise from this article that Mangum believed that her prosecution on the murder charge was malicious. This is misleading and most likely intentional, as these journalists tend to be crafty and very intelligent. As in many articles about Crystal Mangum, Spectrum News falsely avers as fact that she falsely accused 3 Duke Lacrosse players of rape in 2006. Bad as the CBS 17 News and Spectrum News coverage was, that by WRAL-5 News was not any better. Its headline, for example, is an art in misdirection when it states, quote, "Judge rejects new trial request by Crystal Mangum," unquote. Although buried in her pleadings, Mangum may have sought such relief, this case is, at its core, one of malicious prosecution for the larceny of chosen action charge, for which she was found not guilty. The defendants being Durham Police Officer Mary Ann Bond, whose identity was shielded as per most media coverage of this hearing, and the Durham District Attorney's Office. Specifically, Mangum claims that Officer Bond lied to the grand jury in order to effect a larceny of chosen action indictment. False testimony under oath by the officer is a felony. Officer Bond, in allegations of Mangum's complaint, is guilty of the commission of a Class F felony crime. The uppermost photo in the online article, as per media custom, falsely claims as fact that Mangum made false accusations against the Duke Lacrosse players. Though not materially relevant, Mangum was not convicted of stabbing her boyfriend. She was convicted of his murder. That Mangum stabbed Daye is not, and never was, in dispute. The Durham County Judge, an appointee of Governor Roy Cooper, is not mentioned by name in the opening sentence, which is used to further misdirect its audience to believe that this hearing was about a request for a new trial, and not malicious prosecution on a larceny charge. WRAL-5 News is oblivious to the truth when it stated that Daye died after he suffered complications from his injuries. As previously covered, the stab wound, his sole injury, was successfully treated at surgery, and there's nothing in the medical records to support that the wound or its treatment led to a complication. The news staff is aware that Daye's death was initiated by medical malpractice of Duke University Hospital staff, specifically an errant esophageal intubation for treating DTs, and that it had nothing to do with the stab wound. Again, because the merit and strength of Mangum's malicious prosecution complaint about the larceny of chosen action charge was solid, WRAL-5 News portrayed the District Attorney's Office argument as being based on expiration of the statute of limitation for her request for a new trial, rather than malicious prosecution. The gatekeeper rule issued by Judge Thompson was confusing, not only because in requesting it, City Durham Attorney Rayberg based her motion on actions and incidents involving Sidney Harr, not Crystal Mangum. Furthermore, Harr, who was not allowed to address the court, was the individual against whom Rayberg requested that such an order be enforced. The person against whom Thompson's ruling was made, if any, is vague. Undoubtedly, its implementation is designed to protect defendant Officer Bond, who committed perjury, and the Durham District Attorney's Office, which suborned perjury in Mangum's 2013 trial. The News and Observer has long entertained a policy of avoiding articles about Mangum, quite the contrast to its excessive coverage of Durham's Michael Peterson case. The N&O went out of its way to prevent its readers from knowing the truth about the Mangum hearing that took place on the afternoon of Wednesday, August 15th, by withholding publication of the Virginia Bridges article until the following Sunday of the 19th. Burying it at the bottom of the obituary page in the end of the Triangle and NC section. And then carving it into a few paragraphs that conveyed no meaningful information or understanding about the event, which was journalistically well presented in its entirety in the Herald-Sun. The Associated Press article magnified the unfavorable ruling against Mangum by stating that lawsuits, plural, were dismissed. Again, the article doesn't specify that Mangum's single complaint was directly connected to the larceny charge for which he was not convicted in the 2013 murder trial. These omissions are crucial in misleading the public. Though the AP article noted that the defendants argued technicalities of untimeliness of filing and improper service, it did not mention that Mangum argued the legal merits of her case, which were never disputed or challenged. Like other media types, the Associated Press falsely claims as fact that Mangum's accusations in the 2006 Duke Lacrosse case were false. Failure to attribute the Declaration of Innocence to then Attorney General Roy Cooper leads the reader to believe that the supposed determination in the Lacrosse case was made by the court. Averments of Mangum's Duke Lacrosse story crumbling and questions of her mental stability are nothing more than suppositions disguised as facts.